but we'll pretend like you're up close. It's my honor and privilege to be the moderator of this panel. My name is Arthur Pearlstein. I'll explain who I am in just a second, but first I just wanted to very briefly introduce the panelists. I'm just going to basically give their titles because you can find out much more about them. They're a very esteemed group of panelists. First is Jeff Hirsch, who's the Associate Dean for Academic Affairs, and he's also a Distinguished Professor of Law at the University of North Carolina School of Law. He's to my immediate left. I'm going to wait and introduce the guy in the middle in just a second, but on the far end is Nicholas Collins, who is a management attorney for ArentFox, which is one of the top law firms in the country. Our third panelist was going to be Kyle Arnone, who's the Director of Collective Bargaining for AFT. Unfortunately, he emailed us last night saying he has an emergency having to do with bargaining somewhere in Pennsylvania and wasn't able to make it. But we had the great fortune to be able to recruit literally at the last minute, by which I mean within the last hour or so, the guy sitting in the middle, who is Alec Thomson, who is a professor and he's president of the National Council for Higher Education. So you'll have to, we're going to let him back last because he doesn't have anything prepared per se, but he knows a lot, so I think he's going to be a great contributor to the panel. And for those of you who don't know me, which is probably most of you, who the hell am I? Until just last month, I was, for the past a little over 10 years, the Director of Arbitration and Senior Mediator at the Federal Mediation and Conciliation Service. In the beginning of February, however, I took what has been sometimes misnamed the buyout, which is to say the deferred resignation program. And so I must give the disclaimer that I am not here speaking on behalf of FMCS. I'm not authorized to say anything on behalf of FMCS. All I can say is I hope that FMCS, for those of you who don't know, it's a great little agency that helps unions and employers negotiate collective bargaining agreements and resolve disputes and build better relationships. But in any case, I am here in my capacity as now establishing a neutral practice as an arbitrator and mediator, so please keep me in mind for your dispute resolution needs. In any case, I wanted to start us off. I went to ChatGPT last night and asked it to write, well, here I'll tell you the exact instructions that I gave. Help me write a poem in iambic pentameter about the use of artificial intelligence in higher education, including issues that faculty labor unions might raise in the context of collective bargaining agreements with university leaders. And here is what AI came up with. I have not edited it at all. In hallowed halls where wisdom long has grown, a new device now claims a voice its own. With circuits bright and logic deep refined, it aids the scholar, quickens student mind. Yet whispers rise in chambers, soft but stern, as learned hands their rightful wages earn. Must we, who shape the future's keenest thought, compete with tools so easily begot? A tutor swift, a guide with endless reach, yet lacking soul, no mortal sage can teach. Can wisdom stem from code and mirrored glass, or does true learning through communion pass? The union speaks with voices proud and clear, to guard the toil of those who labor here. Will AI grade, will AI write and read, or strip our art down to mechanic need? Shall terms be set in careful just accord, ensuring craft is valued, not ignored? Or will we yield to dreams who chase the cost and watch our ranks diminish, titles lost? The bargain struck must hold our worth in place. A contract.
Ideas or concerns are, and it's no different. There's always been plagiarism. There's always been people who are willing to cheat to get an advantage, and so you're hoping that there's some level of self-policing that takes place in this particular higher education.
Two parts I would suggest that one is defining what the ethical violation would be, and then policing it is another component to it. Policing is problematic, I guess. No more than other pieces, I guess, checking it. But this goes back to the argument from a CDA perspective. That might be a very broad, difficult piece to get into, because as you dive down into different disciplines or even sections of your campus, I may find that there's considerable difference in what you think is the appropriate use of this technology. And I would argue it's probably down to the instructor level. Again, you could do it outside of teaching faculty too for these areas, but clearly defining that lays out the parameters under which you think that would be, and it may vary across the board. I think this creates a challenge not only for the universities, but also for students, right? Because they run the risk of having a schedule that faculty that are across the range of acceptability on this, right? Some are steering into it and saying, we're going to use this openly in our classroom, and others have a zero tolerance policy whatsoever. But I think it was both Jeff and Nick spoke to this a little bit about the idea that the range of it is out there, right? We are embracing technology that we don't think is intrusive, right? Students are using the spell check, anticipate, expect you to sort of do that. If they have generative responses coming out of ChatGPT to write their essay today, that's clearly out of bounds in my particular class, but others are using it to generate the essay and then react to it, and they see it as an acceptable piece. So the difficulty really isn't defining where you see an ethical violation, but I think you owe it to the university and your students to try to define as clearly as you can from them.
Yeah, just to reiterate all that, which I agree with everything everybody said. I'll maybe make this a side note reminder. A lot of faculty, some are much better with this than others. Some could barely handle Zoom during the pandemic. And so that defining things for them can be particularly helpful, because getting law professors, I think, in particular, are definitely ostrich in the sand kind of mode. But then I'll just give one super recent example for me on this issue, which just really underscores what Nick and Alex already said. Literally Friday, I had the editorial board of the journal that I advised come in with me to talk about a problem, which was one of the staff members, they believed, had used AI to write their note. It went from, the initial flags was a human editor seeing like, there's some things that don't add up here, that look weird. They then also used a couple different AI tracking sort of software programs, while acknowledging that those aren't always perfect. And so figuring out, well, how are we going to detect that? In this particular case, I think it was pretty clear. But closer calls are really going to be tough. And it goes to the process and ethic, like all the other things that everybody's been talking about. So it's here for sure. And again, faculty have very different takes on it. Just for whatever it's worth, I personally will allow my students to do AI, but they have to tell me, they have to cite to it and tell me exactly how they use it. So far they haven't used it, or they haven't listened to it, because I think that's more of a pain than it's worth, which is maybe a little bit of the point. But I don't think there's a right or wrong way, but being clear about what's allowed and what's not is important.
By the way, how many of you thought that the poem by AI that I started us off with was pretty good? Yeah. How many of you thought it was no good? I actually wrote that poem myself. I was just kidding. No, it really was AI. It wasn't me. Okay. Let's open it up to questions from you folks. Questions, comments. The only restriction I would ask, and I usually have to say this because I often address groups of arbitrators, and it may not apply to you folks, but for groups of arbitrators, I always have to say, please don't make a speech. If you have a question or even a comment for the panel to respond to, that'd be great. Something way in the back, you've got a hand up, please. So scream it out.
Sure. First I'll say, as an English professor, the poem was accurate but formulaic. So if you value some sort of novelty in art, it's not going to be that. But I just wanted to comment, and I'm interested in what folks from the panel might say. There seem to be two different threads. Alec, I really appreciated your remarks on what do you already have, right? And what are the priorities that you've already sacrificed to negotiate, right? And to get those things. And then how does AI really, kind of fall into those existing categories? So there's that. And then there's the question that I'm not really sure if we could fully address in collective bargaining agreements, which is about the individual disciplinary standards, right, that we want to apply in the various fields in which we work, right? To what extent are artificial intelligence tools legitimate in your field for writing, for data analysis, and those kinds of things? So it seems to me, and I'm speaking from a faculty perspective, this might not be as relevant for staff and professionals, but it seems to me like there's kind of two areas there, right? And I think it behooves us to not mix them too much, because there are things that go in a contract, and then there are things that we have to devolve to our departments, to our disciplines, to our disciplinary associations. And so that's a kind of two categories that I was noticing in the remarks here, and I'm just wondering if anybody else has kind of thoughts on that or something that's adjacent.
I'll just add a really quick note and then turn it over to them. So the Writers Guild contract does touch on your latter point, in that it, among the other provisions, it expressly gives writers the ability to use AI in their work. So you could negotiate that if you wanted, but obviously the context matters.
Yeah, to the degree of exactly what you're saying, to what degree do you empower or expect individual departments or disciplines to self-regulate or determine the thing? That, it's a bit of a tangential, I think, discussion, but it starts to wander into the academic freedom discussion area. So what curriculum do you have? And this is more of a, I guess, pedagogical, technological issue that sort of comes into it. But I think you will find there's a wide range not only across departments, but disciplines, even within departments. And I think it's on those departments to decide if there's going to be a standard within that area that may be outside accreditation bodies or agencies, depending where you're at in the field. Or even within those departments, you push down and say, we're going to let this go as an instructor by instructor sort of reality. We see some of this on common core syllabi issues already, textbook selection issues. I mean, there's some prescriptive pieces, right? Your course description, right? But it varies from campus to campus and sort of what you sort of, but I think that falls in there. The real challenge, though, I think, is that it does have a cross-discipline cut to it, because it's an element that's available for any student experience in any field you're in. So it's not strictly curriculum, so it's we do owe, I think, a bit to students at the university, I think, has interest as well, in creating some understanding. So the thing that I did in your class and my class and next class was unacceptable, marginal, and okay, right? And I have to sort of weed through that. Where traditionally we would have said that plagiarism, right, or cheating was all universally unacceptable. It still is, but I think now the definition of what falls in that category of this tool usage falls in that is less clear. That's not a great answer that I get you there.
I think my colleague addressed it. I'm not sure if I can add much to this, but I think, to your point, really developing the scope of what is deemed acceptable versus unacceptable, and utilizing tools. I think that's where you have these conversations where committees are formed to address, hey, if we need a tool that's going to be used to detect the usage of AI, how do we select that tool? Because obviously you can't just have an arbitrary, hey, we did something on Google and we found this tool. It has to be vetted, and there has to be consistency and utilization across class to class, department to department. So I think that's going to be the bigger issue, is when we're starting to grasp these issues, are we ready to collectively discuss them? And sometimes the committees can do that, because you can have these conversations across various different sectors and various different disciplines to come to an agreement about a collective or consistent way that we can evaluate these issues that arise from your economics 101 to advanced neuroscience.
Yeah, and I just want to add, as far as what goes in a collective bargaining agreement, I think Alec and maybe others of you mentioned, things are changing so fast that, and collective bargaining agreements tend to last a long time, that what we put into a collective bargaining agreement today may be totally irrelevant, next week, not to mention next year. Okay, we have a couple of things that have been written down. So the first one is a question. From a union perspective, although I think that the administration has an interest as well, how can we protect our members and workers from bias in decision making? Is there language or provisions we can include in our CBAs? And I assume you mean bias, due to AI. And I would just add to that question, and are we sure that that bias is worse than a regular human being's bias? But anyway, who wants to take a shot at that?
I can answer. Speaking of professor, keep yapping. Yeah, and this is the big, at least from a scholarly perspective, I think, probably been the biggest area in AI. And as Arthur said, it could cut both ways, right? There's a potential that a really good use of AI could actually reduce bias or other types of discrimination with regard to hiring, promotions, things like that. But it's probably surprise no one. Oftentimes that ideal is not met in practice, and so we've dealt with how to handle AI actually creating bias. And just as an aside, maybe it's worth just noting kind of how that might happen. And I think probably a lot of you have heard about this example already, but I'll repeat it because it's a good one. So many years ago, Amazon, and I should note to their credit, I'll say often, they actually never implemented this officially, but they were experimenting with AI as a hiring tool, basically ran simulations. And what they were discovering was that the algorithm was comprehensively weeding out every applicant that it could figure out was a woman. Like, anything in their resume that suggested this applicant may be female, they would pull out. Why was that happening? It was because when they set up who a good applicant or a good employee is, right? And this is like a key aspect of using AI. Like, what is it shooting for? Amazon used its then existing workplace data, which was dominated by men, and so the algorithm learned to equate good employee with man, and the result is what you saw. And there's all kinds of other problems with using that data, things like that. So when Elon Musk talks about using AI in the federal workforce, right? These are all the kind of issues that'll come up, right? Title VII and other laws they are not built for that, right? It would be virtually impossible, I think, in most cases, to find discriminatory intent. You might theoretically have it, so then maybe you have a disparate impact claim, but that's super hard to win. So I do think that contracts could be super important. You could, of course, ban it. Would be one goal. Just you can't use AI for these practices. What we started to see in some, I think I referred to this briefly, in like New York, California's got a kind of proposal kicking around. Is more sort of notice rights, things like that. I'm not sure, frankly, how much that does. It's better than nothing, I guess. But you could also control how they use it, right? Sort of as we've been talking about, trying to address some of the problems I noted with the Amazon example and trying to mitigate that. I don't think there's a perfect answer, though.
It's people. The idea of eliminating bias is not a new issue or concern, right? We have it even before we have AI sort of concern. I would point back to collective bargaining structures that empower you as a faculty member or classified or XP to serve in decision-making roles. Whether you sit on a curriculum committee, a hiring committee, a tenure review committee, and you have the right to raise your voice, raise your concern, and say, these are the evaluation concerns or considerations we have. I've done on a hiring committee before where the human resource department says, we'll pre-screen people and let you know the list of pools of applicants that are already there, right? Well, depending on who our HR director or the situation we're having on campus, I was less trustworthy of their pre-screening, right, than I was of having the opportunity. We had a right to say, thanks, we appreciate making my job more efficient. I know we had 300 applicants, but I will go also and look at all 300 as opposed to 15 that you thought were the best ones that we should already go and look at, right? And essentially technology in this case would be used to do the same thing for you, right? So it's not your AI director or employee relations person, someone else can go through and say, this has come through, these are the ones you have. You still should push back and say, you know, I'm on this committee, I have this role, we have a responsibility, I want to be able to look at these things. Doesn't mean everything immediately happens, but you do have sort of agency in that area, and it takes more work on this end regard, but I think that the way that you structure those kind of points, those fulcrums, if you will, that faculty are on there, and I suspect our campus will switch on this, but you may find in some of those committees that you have a majority faculty voice on those, at least at some stage, right? There are more faculty than administrators on some stage of that committee, or you control the curriculum, or there's academic senate, or something along those lines, you know. Don't let the efficiency option, right, preclude you from still engaging in your work or raising your objections. It's not a cure-all, right? There's still a way the final decision is outside of your realm for that. But it does not mean you have to acquiesce and sort of say, I'm not participating in that. You could raise those concerns still. I still think they're legitimate.
Right. I think it goes back to what I was saying, where a lot of employers are looking for AI to be an aid and something that can be utilized in conjunction with actual faculty members, and that's important in weeding these things out. So, for example, maybe you're combing through resumes, and maybe the faculty will maybe look through the resumes beforehand to see if there's ways to weed out language that may signal a membership in a protected class or protected category or not, so that you avoid these issues that could arise through implicit bias, or also just troubleshooting and making sure that you're reconciling that this AI tool is actually accomplishing the goal that we implored it to accomplish. And so that's the important thing, remembering that this isn't a full replacement for whatever task you may have been given, but more so a way to become more efficient. But obviously you want to make sure that ethically the efficiency isn't just overriding everything, and you're still reviewing to make sure that it is accomplishing the goals of the committee, accomplishing the goals of the department, et cetera, et cetera.
Thank you. Okay, I'm going to get to you next, but there's one more written one that I just want to get through, and it's more of a comment, but for anyone on the panel to respond to. As a faculty member and leader of a labor union interested in bargaining for the common good, I'm interested in plagiarism, utilization, automation of our workforce, and environmental impacts. The environmental impacts are significant, but rarely discussed. Curious what the panelists' thinking is on this. Anybody have any thoughts on environmental impacts?
Just briefly, I'll say the NEA recently released their study on this, and that was one of the hallmarks of that discussion that was actually spoke to that. So if you want, it's on NEA site, you can do NEI task force, and that was one of the, I guess, unique clients that spoke specifically to environmental impacts coming out of that. So I'll just put a plug in for that report if you want to see it.
Give it, this gentleman right here.
Yeah, I don't know if you have an answer to that question. You know, I was on a search committee recently, hiring administrator, high-level administrator, and we had the distinct feeling that some of those applicants, they use AI. So the cover letter and everything, it read like chatbot thing. Now the thing is that because it's protected information, we can't do any of the tools, right? So we can't do zero GPT or whatever it is. And then the hiring process is so structured, human resource overreach, you know, you can't ask follow-up questions, and the questions are so structured So we had interviews, and then we felt like, well, it looks like even the answers are, yeah, we can answer. So we are left with the feeling that are we having chatbots as our administrators? So what do we do in that situation, right? Because and we have multiple faculty, and they all sort of have the same feeling that this looks like is ChatGPT going to run the place now? So what's the way out of that? And this is still a little bit biased, right? Human resources, structure, everything, but then now it's sort of, handicapping us.
Did you make a hire in that situation? Or did you have a failed search, I guess is the question.
No, we are still,
Still going after, so. Yeah, I guess so, I don't have a magic bullet answer for you on that, but I would say some of the issues you're raising are older than AI, right? I think we probably had served on panels where, the application you got did not match the person that seemed to walk in that room when you interviewed them, right? Like, they seem very polished, they seem to have great credentials, they seem like they'd be a dynamic, interesting person, and they sat down in that room with you, like, man, I can't do 25 years with you, right? That's just not going to work out. I don't know why I thought this was going to be great. And maybe someone else wrote their cover letter for them, or someone helped them with their resume, or they had a career coach that said, I'm going to walk you through 10 things you should say in an interview today or something, and they seem very stilted. Those things come out, but it is the in-person piece that you get the chance to evaluate that. I don't have a magic answer to sort of say what to do on that, but I would say, if you faculty can push on that to say, we don't think any of this meets what we're doing, or we're unsatisfied, or, maybe it requires us to restructure how we do hiring processes, right? Maybe cover letters are just not that interesting or useful for us anymore, right? That stop requiring those to come in because everyone's, writing material that we don't think, we're just looking for an error in them and sort of disqualify you because you got the address of the school wrong, and therefore you're not a person who's considered with detail. Maybe that's a restructuring, or maybe AI will force us to think about the entire committee or application process. We want different things out of it. We want longer in-person discussions and less formal written material. I don't have a definitive answer for that, sorry.
I can say beyond the higher education context, HR departments, especially in the non-unionized settings so far, are making more and more major use of AI in the recruitment, hiring process, evaluation process, and everything else. And in a lot of cases, unions have protected against that. But, yes, sir.
Yeah, just really appreciate Alec's perspective on using tools that already exist. I mean, before there was AI, there was Alan Sokol, if people remember the Sokol affair. Before that, there was Sarah Note Bergerac, right? So what I'm interested both in the panel's opinion and also in crowdsourcing the wisdom in the room. I'm the chair of bargaining for the California Faculty Association, and we are just beginning successor contract negotiations. AI is going to be a big part of those negotiations. I've done a lot of thought on it. I appreciate Jeffrey's perspective. He's looking to the SAG-AFTRA and the Writers Guild. Obviously, they went the direction of having a standalone article in the CBA. This is very much a brass tacks question, not a lofty comment. So it seems like there's two directions, right? I mean, you could have a standalone article where you're trying to address everything you can think of, understanding that it's going to change down the road. Or you can go about it sort of piece by piece, because it touches non-discrimination, it touches appointment, it touches evaluation, it touches workload, it has to do with lots of different areas of the contract. So what do you see as the positives or negatives of each of those two approaches? Panel and also wisdom in the room, find me later if you have thoughts.
Panel?
Yeah, clearly I was an advocate for viewing it as part of the entire document, though I think there is some value in addressing it as a specific article. So my campus, we don't have anything on AI in our contract, but that's just a product of timing, right? Our contract will expire in 2 years. And I'm sure that we spent all summer talking about AI at that point, right? We did it 3 years ago or something. So You know, I look back over our own contracts over time, and it's not a perfect analogy, but the way that we moved to distance learning education, that many years ago, we didn't have any language on that, and then it was simply an appendix and a memo, and everything was treated as a supplemental or special case or a pilot, and then it sort of moved into, it's pervasive, it's a central part of what we do now, so teaching online or remotely or whatever you're classifying is viewed as part of the umbrella of everything else, student support, base load, supplemental, student rights, all of those things are now sort of incorporated into that, which once was a whole separate kind of entity. It's not exactly the same that you're sort of speaking of. My concern about treating it as a separate entity is that it pulls it away from all the things that I mentioned earlier, right? That it somehow says that AI stands alone from things about due process, or it stands alone from academic integrity, or stands alone from tenure promotion. And that I feel like you're constantly trying to then create a second contract to make sure that when you're talking about AI, you're still protecting all of these core principles that I think are the driving force of why you had a CBA in the first point. And I kind of worry when you pull it out, then you just read it as AI here exists, and that you no longer talk about all the other pieces, unless you explicitly include in your AI appendix or section that we are also talking about compensation, workload, tenure promotion, and then I feel like in some way maybe we're just recreating contract part two. That's my personal view on that.
Wisdom of the crowd. Anybody want to respond to the gentleman's challenge about putting a specific AI article in the collective bargaining agreement? I guess we don't have much wisdom in this crowd. No, I'm kidding. Okay, more questions? Yes, sir.
I'm Scott Sommer, actually, and Phil Arthur took the fork in the road when we were colleagues together at FMCS. I'm still currently employed by the federal government as of 12/15. Ask me again at 12:30. So I've been seeing this AI in every industry I've been touching in the last few years, from building trades and construction to most recently nursing. That was quite a conversation. AI and nursing. Ask that God forbid you need to be in the hospital, please check with your nurses to how they're getting the diagnoses, because it's happening. Sometimes it's put on the table by management, sometimes it's put on the table by union, but the question I have is kind of not wisdom to the prior speaker, but actually dovetailing off of it. We all acknowledge that contracts go, 2, 3, 4, sometimes 5 years long. This stuff is changing every day. So I'm curious, because I've been seeing different kinds of solutions, and obviously universities are much more complex than the average workplace, because you have everything, you have large universities where every department chairman do their people, no offense, the heads of the university think it's their people. So it's like, you have all these competing things going on. I'm curious as to what people are seeing in their contracts, to the extent they have anything, or to the extent in conversation. Is this going for labor management committees for ongoing review, where there has to come to an agreement, or is it the union gives input on proposals for management will have the final decision, or is it there's a panel set up of experts who are going to do. I'm just curious as to what people are thinking about, because I'm seeing them addressed differently in every industry I'm touching. And if anyone there regulates, says anything on that. Because you got to write something in the contract, right?
I'll just briefly, I think the way they come up initially, if they're not in your contract, is they come up through a discipline complaint grievance scenario. So something happens that someone takes action on, it's AI related, and now it's a question of, was that action appropriate or the reaction to it appropriate? And now we're into the contract to say, how come my dean did X, Y, or Z, or how come the student's now up for review or something, and they want to challenge the right of this particular person to do it. And then it gets into the general contract language. But until the right contract actually openly talks about AI, it really generally, I would say, stems from a problem that comes up. And when we get enough of them, then we usually see kind of labor management, often informal meeting, like how are we going to navigate this going forward, and kind of, I think, leaning towards the next contract negotiation. If it's critical, sometimes we do see good put MO that we use to go together to sort of say, and you often just say, well, create a committee that work on this and roll with that contract. But it often, I think, comes up through a challenge or a problem resulting from something that was AI driven, often student or disciplinary related. That's what I'm saying.
Yeah, and I'll add, this is, I don't know how relevant this is, but I'll say anyway. So, right, I'm at the University of North Carolina, so we don't do collective bargaining, thank you very much. But one thing that's been going on there that I had been thinking about, sort of along the lines of what the previous question referred to is, so the university itself has been making a big push into AI, just, you know, from an academic research perspective, to the point where there's, you know, creating various committees, groups, I can't keep track, it keeps changing, much like the technology. And it's still fairly early to my mind in the process, but even something like that, which I don't think is created, at least with a primary goal of sort of looking at AI's use actually at the university with regard to students and faculty, but it certainly could, right? And that would be a way sort of, you know, you could at least defer in some part to a committee that's actually made up of experts in those fields that can react to changes as time goes on. I'm not so sure about how that would actually work, sort of, you know, writing contract language or things like that. But you know, there are other ways that the universities are already sort of doing AI stuff that could help at least with some of these issues, particularly as they develop.
Yeah, the question mentioned labor management committees as one option. That's something I think is a great idea because it's so much in flux. Having, you know, labor management committees involved in just regularly looking at the issue, I think has some promise. Okay, what else out there? Don't worry, I'm gonna cut it off, but, you know, at least a few minutes before lunchtime, because the last thing, not just lines, but shield and grace. Let AI serve, but never steal the stage. For minds, not machines, must shape the coming age. And so that's AI's contribution from me. I've had a great interest in the area of AI in the world of collective bargaining because we don't even know what we don't know yet. There are tremendous developments every day. I had a particular interest in the use and potential growing use of AI in the context of arbitration, but our panel is going to talk about AI in the context of collective bargaining agreements and other issues in higher education. And with that, we're going to have Jeff start us off.
Thank you, Arthur. I'm not sure, did he give himself a grade for that one? So welcome, everybody. Thank you so much for being here, and I want to thank the conference organizers for inviting me and my fellow panelists. So again, as Arthur said, we'll be focused obviously in this session on AI, collective bargaining, and then of course with attention to higher education. I'm going to speak more generally, I think, at first, talking about some of the work I've done with regard to collective bargaining and sort of the governance of AI. It's sort of a gap filler because, as we know, there's not much, if any, governmental regulations of AI. I'm going to try to keep my remarks fairly brief in the hope that we'll have a good Q&A because I sometimes find that to be some of the more substantive parts of the discussion. But I want to start with the idea, just to sort of throw out the idea of the fact that when we talk about AI, we're really talking about a variety of different technologies. You know, the term itself is a fairly old one and sort of encompasses some of the early ideas or attempts to use computers or other technology to try to mimic human intelligence. There still is some work being done in that, and to the point where it's getting a little scary. But largely, when we think about AI in practice today, it really has nothing to do with that. Right? AI instead is a much more global term that gets applied to various technologies, you know, computer algorithms that accomplish a variety of different goals. This, just as an aside, is something that at least I have seen a lot of people not appreciate You know, the infamous examples of lawyers using ChatGPT to do legal research. That's not what it's for. That's a language model that tries to generate language that sounds good, but it's not doing legal research, right? So just because it sounds good doesn't mean it's accurate. There are, you know, see Lexis and Westlaw, legal research AI tools. There's a variety of other types, generative AI. I know Nicholas is going to talk about that some. We also see in the workplace AI being used, so-called people analytics as a way of sort of managing workplaces. That includes scheduling, data analysis, data collection, sometimes even selling that data as an additional revenue stream. There's a variety of other types of AI that are targeted to different uses. Right, it's a lot of, you know, sometimes I use an analogy, you know, there's just different tools in a toolbox, and it's important that people recognize when they're using AI or types of AI, what that tool is actually used for and what it's not supposed to be used for. And in the workplace, of course, we see a variety of these AI uses. You know, the things that I've mentioned, a lot of monitoring. Not a surprise, right, that since I think the dawn of employment, employers have been very interested in monitoring their employees at work, and AI can be quite effective at that. Also, we see a lot of current or previous types of automation then being combined with AI to better analyze either, you know, what surveillance cameras are seeing, what, you know, searches of networks, things like that are doing. So AI is oftentimes not a standalone device, but it can be used with other types of technologies in the workplace. Now, this, like any other tool, are good. There's some good things and bad things about it, right? And obviously the bad is the central focus, although I will note some potential positives as well. You know, among the concerns that employees and employers at times as well have, you know, the number one is job displacement. Right, like technology throughout history, a big concern of workers is the possibility that AI, like other types of technology, might literally replace them. Right, this is the Luddites, you know, on up to the present day, and that certainly has been happening. We've all heard reports or seen examples of that. You know, and I can get into this more in the Q&A. You know, there's certain types of work that is much more easily automated, but with AI on its own or with a combination of things, tends to be more sort of rote, kind of repetitious type work. Side note, for you all, lawyers less so, right? There's certain aspects of our work that are more susceptible, but you know, people's role as a counselor is AI is not particularly good at that type of subjective, ethical, those kind of soft skills. But right, job displacement is a huge concern, and when we see issues in the workplace, oftentimes that's an important part of it. And then similarly, just changing job duties. You know, anybody who's old enough to remember sort of the dawn of personal computers, right? There's been a pretty radical transformation. Just based on that, and I think AI has potential to be as big, if not bigger. You know, that can be sort of a pro and con, right? That for some workers, and if you can look at the surveys, it'll oftentimes illustrate this, right? Workers have mixed opinions of it, right? Some of them are encouraged by the prospect of getting rid of some of their road work that they don't particularly love, but then they're concerned that there might be effects either on the amount of work that they're able to do, so a sort of direct impact on their compensation, or, and I'll talk about this more in detail in a moment, to the extent that it's changing their work, that could also end up reducing their compensation, right? So there's the changes in the type of work are oftentimes important. There are a variety of other issues that you can see with AI. I mean, bias and discrimination is one I think that has probably gotten the most attention. And this is another one where there's, you know, promise of a benefit, but a real threat of some potential harms. Right? There's a lot of now AI companies that are selling their products as a way to reduce bias, whether it's hiring or other types of workplace decisions. And there, I think there is, legitimate promise there, as we all know, humans are not always the best with that. But then on the flip side, and again, I'm happy to talk about this more in Q&A, people have to be very careful with the way they use AI, because if they don't use it carefully, it could actually create more discrimination. And the current law, Title VII, and other related laws are not well suited to dealing with those types of cases where you might have AI-driven discrimination. Just a couple of other sort of impacts on the workplace. I mean, safety is a big one, and I think a big potential positive. Maybe less so in sort of most higher ed jobs, although there certainly are plenty of at a university that could be, that have a variety of safety concerns. And AI actually can be quite good at reducing, mitigating various safety concerns. There's some other issues as well, although just because of time I won't get into those because those are the main ones. What I wanted to sort of focus on now is it's sort of twofold. One, again, as I think be no surprise in the audience, there really is no meaningful regulation of AI, particularly in the workplace in the US. At a federal level, there's basically nothing there. The Biden administration had produced some executive orders to try to sort of promote better AI practices in the federal workforce. There's been some movement on that before the administration's change, but not a lot. Senate has also some efforts along those lines, but it hasn't produced any sort of legislation at this point. We do see some efforts at the state and local level, New York included, trying to regulate certain aspects of AI use in the workplace. Those are pretty limited though, either by scope, and New York's provision has gotten a fair amount of criticism just because it's a very narrow scope, and so really hasn't impacted many workplaces. And then just as to what it even covers, oftentimes at most they might require certain information to be provided, notice to employees, things like that. But there's not really any sort of substantive limitations on AI use. And so at that point, right, that's leaving employees pretty much at the will of their employers. And here's where unions, of course, can come in, right? This is, I think, right, and unions are in a particularly good position to really help fill that regulatory void. They have, of course, the resources that employees don't have, and frankly, a lot of legislators don't have. They, of course, have the interest and already relationship with workers. They're also better able, I think, in the collective bargaining process as a whole, is better able to adjust to the particular needs of a particular workplace or industry, oftentimes in a much, much better way than any sort of government regulation is able to do. Now, there's, of course, limits to that, most notably being just the level of union representation or the union density, particularly in certain industries. But where there is a union there, I think it can be quite important. And just as a prime example, and of course, and we'll talk about this, I think, throughout with my fellow panelists, is the Hollywood strike and resulting collective bargaining agreements, both with the writers and the actors. Right, both of them engaged in strikes over 100 plus days. I think just about Netflix has worked its way through all that, pulling up your favorite shows. And one of the, although it wasn't the only issue, one of the key focuses and holdups that resulted in those two strikes was the use of AI. Again, I'm not going to get into a lot of detail now, but I'm happy to do it more later. But one of the things I just wanted to sort of stress is both with regard to the writers and the actors. In neither case did you really see the unions try to prevent, in a wholesale manner, the use of AI. It was much more of a focus that this is a new tool. We're not going to be able, either we don't want to or we're not going to be able to completely stop it. But, like any other sort of new tool in the workplace, we need to set up a regime to help control its use in a way that protects the employees, right? And so for writers, of course, that's where like a ChatGPT or similar AI program is important, right? To the extent that someone can use AI technology to write something, also important, of course, in the higher ed context. right, the writers are extremely concerned about that. The actors, we're looking at more of the visual and types of AI where companies can, either based on a human actor or just on its own, create a digital actor, model, variety, any sort of picture. Again, that's, if you can start to look at some of the recent examples of that, it's getting eerily good. And in both of the cases, the writers and the screen actors, they were able to, although not perfect and not getting everything they wanted to, ensure, on several different levels, either limit to some degree the extent to which the Hollywood studios could use AI. Maybe they need to get permission from a writer or actor. Moreover, and particularly with the writer's side, there was a lot in the agreement to try to ensure that writers were getting full compensation for work they were doing, even though AI might have been part of the screenwriting process. And so you have this sort of classic job protection, compensation protection concerns that we see in virtually every collective bargaining agreement, just, again, with a brand new technology. So my final thing I just want to say before I turn it over to my fellow panelists, there's another area that unions and collective bargaining can help in the regulation of AI, and that's actually working with employers, right? And AI is an interesting issue, I think, because maybe unlike a lot of other issues, there is some overlap in the interest of workers and employers. Not perfect by any means with regard to AI. In particular, anytime you have an employer with intellectual property interests, they are no fans of the AI companies, right? There's a bunch of lawsuits going now with Hollywood studios, people with copyright holders, patent holders, objecting to AI companies scraping the various intellectual property they're producing for their own purposes. Here's where unions, even outside the traditional collective bargaining process, can help lobby with potential employers. Microsoft and the AFL-CIO have a framework where they're working together, and again, there's a lot of complexities to it, but part of that also involves not only education and training for workers, but actually having more of a united front in dealing with potential government regulation or potential legal action going down the line. And again, we're seeing sort of that aligned interest producing a little bit more cooperation, I think, than maybe we've seen in some other areas. And so, all of these issues, I think, are also applicable frequently to higher education process. The novelty of it, I think, is still quite difficult, and this is an area that a lot of people have trouble with. But this is an area, I think, where unions can really play a pretty central role, both in protecting workers and, frankly, protecting the universities if they'll let them. So with that, I've got to sit down and turn it over to Nicholas.
Good afternoon. My name is Nicholas Collins, and I'm going to be speaking about what we're seeing from a management perspective. And before I get into that, I do have to get a little bit of an anecdote, because I'm sure that several people in this room can have a shared experience. I was a former adjunct professor at Cardozo Law School, and I remember distinctly the meeting where ChatGPT was first discussed. It was about 2 years ago, and professors we were having conversations about the concern that students would be using it to generate research and even written product, and would be submitting it as part of their courses. And so during the course of this conversation, which was primarily stemming from an integrity perspective, there were concerns for whether would this be considered plagiarism, or are students who are opting to experiment with this technology, are they gaining an advantage over students who are opting to actually do the heavy lifting on their own? And that obviously was 2 years ago, but there's been a significant development in the utilization of generative AI. And as my colleague was saying previously, there is a distinction, and a lot of what we're talking about in the Yeargan in the news is generative AI, and that's an algorithm that is scraping the internet for data, and then someone could essentially give it a prompt and it will create content. So for example, when we're talking about the SAG-AFTRA negotiations, the overarching concern is, are we on the road to a world where a digital script is being acted out by a fully synthetic actor or actress? And so there was a concern that at some point, are we on the road to James Cameron's Terminator, where we're essentially getting to a place where we're obsolete? And so these concerns and these considerations are continuing to make their way out beyond highly technical industries, and here we are today talking about it from the perspective of higher education. And so when employers are considering whether to incorporate or to require the usage of generative AI, the conversations are typically formulating around 3 pillars: efficacy, ethics, and economics. And so obviously the economics are pretty self-explanatory, but in efficacy, is GAI or generative AI, is it providing a tool that can improve the efficacy of teaching methodologies? And if that is in fact a possibility, then a lot of employers or schools will consider it. And I've had the opportunity to speak to some colleagues in that space, and one of the examples that I thought was important to talk about or to offer is for a teacher who may be teaching a special education course. Could they use GAI to generate a curriculum that could accommodate multiple students with multiple learning disabilities in one single classroom setting? And that obviously would be able to incorporate data that's been pulled from leading experts and leading research to create a curriculum that could address a student who might have dyslexia, while at the same time addressing a student who may have any number of other disabilities. And the thought of that obviously is highly preferred by all, because at the end of the day it would improve the classroom experience. But there are obviously ethical considerations where we're considering all of these things. Are there HIPAA violations when you're talking about a particular student's learning disabilities? Are you uploading data or information that's not self-contained in this product and can then be utilized by someone else? Are teachers and parents, more specifically, are they giving consent? This is another issue that is highly controversial when we're talking about GAI, is consent. Are the people whose data is being mined, have they consented to it being used to create a product or create some other form of content? The tool obviously, ideally, would be used in conjunction with having your educator. This wouldn't be a lot of employers looking at it from the perspective that this could be a tool that is used to improve the entire experience. It wouldn't be used to replace, but to augment and improve performance and efficacy. Unfortunately, also, employers will consider whether or not GAI can be a cost-cutting tool. For example, with the expansion of online courses and online degrees, GAI could potentially be used to generate curriculum and even generate full entire lectures. It could also be used to create tests and potentially grade those tests and those assignments. And so there's a concern that with the expansion of these online offerings, are you creating a market where a traditional educator is no longer involved in the process? And so those are some of the considerations that we're hearing from both sides. Also, just traditionally, technology, especially when it's new, tends to be a very scary concept for individuals or professors who have 20 and 30 years of experience in a particular manner, and now being asked to incorporate something that is entirely new to them. So that is something that's also part of the considerations for the employer. You don't necessarily want to completely upset your entire workforce because they are still being asked to help educate. The looming concern surrounds whether it actually enhances the educational experience and other ethical considerations that come along with that. For example, my colleague discussed implicit bias. Depending on how this particular algorithm was generated, is it providing if you're proliferating it in the classroom, is it providing an unfair advantage to a particular student who comes from a particular background or who comes from a particular social economic status that has equipped them to have such an advantage, or does it actually level the playing field? So those are considerations that employers are going back and forth with constantly. And obviously, setting apart from the actual employer, for those that are participating in a unionized workforce, there are collective bargaining implications. There are obviously from union members, there's a concern whether the adoption of generative AI will alter the terms and conditions of the workplace. Will educators be required to use it? Will it replace certain aspects of their current role? Will it add additional job requirements of them? Is this, obviously there's these conversations about, is this the beginning of robots educating us? And so those are some of the considerations and concerns. Unfortunately, the full extent of GAI is not yet fully realized, as it is in every evolving technology that is making leaps and bounds on a daily basis. One of the other concerns is distinguishing traditional AI that may already be in use versus generative AI. For example, I think one of the clearer examples, going back to the SAG-AFTRA negotiations, AI has always been a part, or has been long a part of the movie industry. You talk about CGI or computer-generated images, that's been a tactic that's been long used. And technically that would be encompassed in this overall theory of AI. And so are employers, and in this CBA negotiation, are they protecting a right that they've already had the opportunity to implement and explore, and just making those distinguishing in a collective bargaining negotiation what is already considered AI versus generative AI, which is what people think of when they're discussing what's happening now with ChatGPT and other programs that are being implemented by companies like Apple and companies like Microsoft. For example, and so how is this actually playing out at the tables, at these negotiation tables? In certain industries, they're a little bit further along, and so they're really getting into the weeds about how it's going to be used, where are the guardrails, where are the ethical considerations when using it. A big issue is consent. Is it clearly being identified when AI is being used, as opposed to a bargaining unit member who would traditionally hold this role to perform a particular task? And so in higher education, where we're still exploring and still learning about how this the proliferation of GAI can affect the workplace, you're finding that a lot of negotiations are creating or solidifying the right to bargain. And also, for example, I've seen collective bargaining agreements where essentially the provision requires that the union be provided adequate notice when a consideration of implementing a policy that would involve AI or generative AI is being considered, and to give that union the opportunity to bargain over its effects. Another tactic that is being utilized are the formation of committees that are collectively between the employer and the employee. They're considering AI or generative AI that could be of use in that particular industry, and making sure that there are adequate guardrails to ensure that an employer, or that the employees are not necessarily being phased out in favor of the use of this AI. And so these are just some of the concerns that we're seeing, but unfortunately, as we continue, this is a conversation where we can have an entirely separate conversation about this tomorrow based on what's being generated on a daily basis. And so ultimately, there are these considerations when we are determining or attempting to determine how AI can best be used in the workplace and how can it better enrich the education of those in higher education, right? And so I think I forgot to talk about it, but one of the other bases that AI can potentially be can rear its head in is our faculty searches, as well as tenure track. The AI can potentially be used to generate postings. It could be potentially used to cull through resumes and research that a particular applicant has participated in. And obviously, that is of concern because there could potentially be implicit bias. And with respect to the tenure track process, it could be potentially used to dictate or to anticipate the productivity of a particular candidate. And again, there are obviously concerns with that because those roles are traditionally taken by committees who are people, and there's that human element that's involved that to some extent could be lost by an algorithm. So typically what we're seeing now, and in closing, what we're seeing now is in the employer union space, unions and employers are finding ways to anticipate how it can collaborate in the event that generative AI presents a tool that can be used to improve the education in space, higher education. So unfortunately, every year, I'm sure we'll have this panel every year, we'll have this same conversation and there'll be something else to talk about. But these are just some of the trends that I've been seeing that employers are considering with these developments that are happening each and every day. Thank you.
Good morning. I wish I had used AI an hour ago. My name is Alec Thomson. I am the President National Council of Higher Education. And for those of you unfamiliar, we're a council within NEA that advocates within and throughout and beyond NEA for higher ed faculty and staff issues. So this morning I was approached at breakfast to stand in and serve as a voice for that. And I hope I won't cover too much of the same ground as the previous panel. So I want to thank Jeff and Nick both for laying this out pretty strongly. But a couple things I want to sort of illuminate or expand on it in talking about it. And just to go off what Nicholas has said in part of his speech is that the technology we're talking about here is changing rapidly. It's changing fast, right? You joked about we can have this panel again next week or a year from now, and it might look a lot different than it does today, but we'd have the same general subject there. And I say that in the sense that we should be, I guess, cautionary to not be too overreactive in the work we're doing, especially in our collective bargaining agreements. Our agreements run for multiple years, and we're going to put something in place today that may want to be utilized or look sadly out of touch months from now, weeks from now, or even years from now. And to go with something that Jeff had said, it's really thinking about the proper use of this tool and where it belongs and where we use it. And I would argue as well that we should think about sort of basic principles, our core principles of what we're sort of talking about. I would argue that we're talking about AI, especially through a collective bargaining agreement arrangement. We should think of it as a tool that serves in support of what we want to sort of do and accomplish, right? Whether that's from the needs of the workers, the needs of the students, or even more broadly, the college and university as well. And to that end, I would think it's worth considering how we use the framework and structures we have in our CBAs now, right? To use that existing language to think about how it is impacted or in the ways that AI may be compatible or incompatible with the goals that we have for areas that are long-standing in your contracts. We had a hint of this, Jennifer Abruzzo, who's the, I guess now former general counsel for the NLRB, talked about this a little bit in the past in 2022 when she talked about the idea that we should, it was her perspective at the time, that we could use language in the National Labor Relations Act that existed to say that AI technology should presumptively work within that framework. In other words, AI did not give you an opportunity to do an end run around that, even though obviously when the legislation was really written, no one was conceptualizing this type of technology, right? The right of you to organize, to have employee rights, to have conversations, to share information specifically about organizing unions, that would still be in place, and the implementation of AI technology by an employer should not infringe on top of that, right? So there's no AI language in the NRLA speak to that, but there is about ways you can infringe upon a worker's rights. And so when we think about CBAs, right, this is not new information, obviously, but we talk about things like workers' rights, we've had this in the panel, working conditions and compensation are core elements of all of our CBAs that you have at your campuses and universities. And embedded within those, right, we have these sub-conversations and topics that you may have stronger or weaker language depending on what you've done or not done on your campus on these areas. So, for example, we're talking about intellectual property, right? This is a long-standing and difficult area, right? Who owns these pieces? Who's generated these pieces? The SAG work that sort of comes out of this. This does apply as you think about faculty sort of generating these things. What control do you have over your own name and likeness, right? Can I have an avatar that's offering all generative lectures, right, for a general section that comes out of this? So those pieces are there. Classroom autonomy, right? The decisions and power you have as a faculty member specifically to determine what goes on and what is acceptable, pedagogical methods, technological uses, right? What are the core principles? And I suspect even in your own departments, you probably find yourselves at odds with some of your colleagues as to what is the acceptable use of that. I know I'm not in the English department, but I have colleagues, right, who are in some hands embracing the use of this to help generate, use as a tool, and students need to know how to navigate those. And there's others who believe it has no place in their particular classroom and should be rejected. Faculty members in the arts talk about the use of this to enhance or develop their final products. Others say, again, right, this is an appropriate use, or it belongs there. It should be cited as co-authorship or co-creator development. Again, these are, I think, debates that you have within your departments, but then also your collective bargaining agreement spells out the boundaries by which you as a faculty member have the right to determine in that classroom, and then more broadly your department, the program, what will be acceptable uses of those areas for consideration. And of course, things like workloads and worker replacements are obviously top of mind here, and we see this coming in different fashion and form, right? So, especially talking about ESP or clerical or classified staff. My campus, for example, has made use of an online chatbot. We no longer have a receptionist that calls in, right? You can, what's your question any time of day? I need help with scheduling, and it goes right off to tell you, here's the catalog. I mean, it's not the most useful tool at some level, but it does replace a person who used to work at a call center, right, and used to direct people to sort of handle that. We've seen suggestions of using auto-grading features in faculty classrooms, right, auto-graded quizzes, auto-feedback on scoring, composition issues. In short staffing situations, we've had administrators suggest perhaps that TA sections or discussion sections could be handled by an AI bot to sort of explanate those pieces, if you will. But again, this gets into worker definition and job definition, unit classification stuff. That's probably already in your contract, right? How are you managing this new person or tool to address that? And then due process, right? I like Jeff's work about language about people analytics. To the degree that we use AI to consider monitoring, right, regulating, checking in, enforcing discipline against you, to what degree do you regulate and expect due process to be part of that procedure, right? If this tool monitors when you were there, or when you logged in, or when you turned things in, that's a technological evaluation. But we still expect, right, that you would have due process guarantees for hearing, or presentation, or representation. We would not expect an automatic discipline, right, to extend from out of that. You just get a notification that your pay has been deducted, or you can relieve your staffing. And then the last one I'll mention here as well, Nicholas spoke a little bit about evaluations and promotions, and hiring for that matter. But to the degree that we expect AI to help scrape, if you will, those applications and bring those sort of things and offer some valuable scoring as part of that team or committee, but also to the degree that we expect the work that we do to be attributed and fully ours or done in combination, right? If those things expected to be attributed in that way. So if I'm up for a tenure review, right? Do I need to distinguish between things that are wholly my creation or work that I've done, or do I need to provide attribution and say, well, I did 80% of this, but I use this tool as well to participate? To what degree those things are valued or not valued in terms of their publication or academic scholarship remains to be seen. But again, I would suggest all those areas, and there are further ones that are on that list, I suspect you have in your collective bargaining agreement. The question I don't get you to come back to is say, what's the principle at work there? Why did you originally put this into your document? Right? Why did you want due process? Why did you want to define the unit classification, et cetera, et cetera? And to what degree does AI as a technology advance or threaten that within your contract? And then you should think about whether you need to add language that sort of specifically speaks to that, or you can just rely on the language there and say this is a technological change that we have in place, and there will be others, and the current principle language you have applies to this new issue, and it'll apply to a future issue as well. And the last point I'll sort of say on this, as it speaks to the center here as well, is that they, from sheer familiarity yesterday, they talked about the database of collective bargaining agreements that are now available. You can search through, you're not going to find a lot of artificial intelligence today. I suspect in the future you may see more of that. But if you do that, do go back to the things I just mentioned. Search those databases that look at those core principal areas again, right? Due process, intellectual property, classroom autonomy, etc. And think about the core things that, again, you think are the reason you create a collective bargaining agreement. And then look at them within your department or within your union through the lens of how AI, again, supports or alters the way that those principles might be applied to your work and to your campus. So thank you.
Thanks very much to all of you, and especially Alec for jumping in. We're going to open it up for questions in just a moment. I've got a couple of questions myself that I think I'm going to start us off with. You may have saw some hand gestures back and forth between Bill and me, and I think, I wasn't certain of whether, but I saw he had blank cards, so I thought he was saying, do you want blank cards for people to write the questions on? And I tried to communicate, no, I'll let people just stand up and ask their questions. Did I get that right? Okay. If any of you were too timid to speak your questions, feel free to come down and grab a card from Bill, and he'll bring it up. A couple of questions that occurred to me as I was listening to some of it. Nick in particular, but everyone alluded to the question of ethics and ethical considerations in the use of AI. It's certainly something that's been of great interest to me in a number of contexts, but including in the context of arbitration. Well, what are the ethics and professional responsibility of the use by arbitrators and by advocates? And the question that arises in that context that I want to ask in the higher education context is, how do you enforce ethics? In other words, very often you don't know whether it's AI or not AI. What do you do about that as far as ethics?
Well, from a technical perspective, there are certainly tools that can help to identify the use of AI. But I think it comes back to the, traditional, when you show up to a college or a university, you have to sign that student integrity. There has to be some type of onus on the actual student or the user of AI to, whether it's developing a policy where a student identifies when they're using this particular tool, whether it be like a Blue Book citation or some other indication. The same being from the perspective of a professor who's using it to develop something. That's part of the ethics. At the end of the day, you're hoping that people will acknowledge that it's a tool that is used to enhance, but is also acknowledging that. So I think that's one of the bigger